Welcome to Middle Class Matters, Business News in English from Dr. CMA Allegation. Hindenburg Research Report on Adani Stock Manipulation and Accounting Fraud. Read in full. Part number 21 continued. Scandal number 1. Investigation stonewalled. An appeals court overturned the prosecution and ruled that the original diamond trading scheme investigation failed to produce tangible evidence. The original investigation and prosecution proceedings spanned 5.5 years and resulted in a 239-page order from the Commissioner of Customs that detailed intricate evidence and findings. In its 2013 ruling, the Commissioner fined Adani Enterprises INR 250 million, US dollars 4.6 million. It also fined 5 other diamond trading companies which it ruled were directly controlled and managed by Adani Group. A further INR 20 million, US dollar 3,70,000 each. Rajesh Adani was fined INR 10 million, US dollar 1,85,000, while Samir Vora received an INR 7.5 million, that is US dollar 1,38,000 penalty. But in August 2015, the Customs, Excise and Service Tax Appellate Tribunal, CSTAT, the tribunal that handles appeals against customs and tax evasion cases, completely dismissed the findings of the original investigation and exonerated all parties involved. It stated in its ruling, in the present case, we find that the Department of Revenue Investigations has failed in discharging the burden cast upon it to produce any tangible evidence in respect of charge of overvaluation or circular trading. In its final point, the tribunal concluded, in the circumstances, we set aside the impunged order passed by the Commissioner and allow the appeals filed by all the parties and dismiss the appeals filed by the Department of Revenue Investigations. The Appeals Tribunal declared that the transaction values were genuine and effectively ignored the extensive evidence trial of circular trading and fraudulent intent. The multi-year investigation was effectively dead, a pattern that has emerged with numerous other investigations and charges that Adani Group has faced in India. Scandal number 2. Money in the iron ore scandal. Adani Enterprises' role in an alleged INR 600 billion, US dollar 12 billion scam involving illegal exports of iron ore. Period under investigation 2006 to 2010. In 2011, the Parliamentary Ombudsman for Karnataka State issued a 466-page report detailing the various methods used by the people involved in the mining industry to illegally lift, transport and export iron ore. The Ombudsman's role is to investigate corruption and maladministration in the state government. The report alleged that Adani Enterprises played a major role in exporting undeclared volumes of often illegally mined iron ore through the port it leased out at Belligeri. The Economic Times Industry SC orders CBI probe into illegal iron ore export by Adani, Salgaonkar Mining and others. Belligeri Port, where Adani Enterprises and another operator were accused of participating in the illegal exports, was reportedly the anchor point for the scam, estimated to have been up to INR 600 billion, US dollar 12 billion at the time. The investigation detailed how companies involved in the alleged scam stole state resources and evaded royalty payments on mined and exported volumes of iron ore. Any quantity of ore extracted and dispatched without paying royalty is illegal. The quantity of ore transported without transit permits, trip sheets, Form 31, Form 27, means non-payment of royalty and also theft of state property, hence has to be treated as illegal. The investigation also concluded that the systematic corruption of state officials amounted to large-scale corruption and complaints of profiteering through illegal mining with the complicity of the authorities in all levels of government, including the state's chief minister. Scandal 2. The investigative documents squarely accused Adani Enterprises of bribing all levels of government. The Adani Enterprises has paid the bribes for getting undue favor for illegal exports. The officials of Port Department, Customs, Police, KSBCB, CRZ, Mines, local politicians and others are involved in receiving the bribe money from Mrs. Adani Enterprises. The criminal cases under the Prevention of Corruption Act should be filed against those who figured in the seized record of Adani Enterprises. Based on documentation seized during the investigation, Justice Santosh Hegde said Adani Enterprises had paid bribes on a pre-ship basis ranging from INR 50,000, that is $1,100 at 2010 exchange rates, to the port director at INR 5,500, $120 at the time, and to individual port staff. Justice Hegde recommended that Adani Enterprises' lease of the state government-owned Belagari port to be terminated and that the company be barred from any future government leases. Scandal number 2. Investigation stonewalled. The iron ore investigation has faced numerous legal hurdles by the government. Despite some political fallout affecting the state chief minister and others of his cabinet, immediately after the ombudsman's report was leaked, there seems to have been little long-term impact, with disgraced politicians returning to the political sphere, criminal investigations stalled, and no clear indication of when or if they may resume. Justice Hegde, the former Supreme Court judge who oversaw the investigation, eventually resigned in protest over the unwillingness of the government to actually do anything about the alleged mass corruption he uncovered. The government seemingly turned its guns on the investigators instead. In a phone conversation, Justice Hegde criticized India's slow judicial process for failing to hold Adani Group and other perpetrators to account. He seemed baffled why, despite the severity of the evidence and allegations, that the Adani Group went on to receive ever bigger government concessions. The cases are still pending, and that is one of the problems you have with slow movement of the judiciary. Scandal 3. Money in power equipment over-invoicing scandal. In 2014, the DRI alleged Adani Group had over-invoiced power plant equipment by INR 39.74 billion, $800 million at that time, indulged in trade-based money laundering, passing on costs to consumers and siphoning funds from its public entities. Period of investigation 2009 to 2014. A 2014 investigation by the Directorate of Revenue Intelligence DRI alleged that two Adani power subsidiaries had grossly overvalued the import valuation of boilers, generators and turbines imported for its power plants. The Economic Times Industry DRI ED set to probe Adani Group for allegedly overvaluing power equipment imports. Source Adani Economic Times. In a summary of its investigation, the DRI accused the power companies AMPL and APRL, related entities, and Vinod Adani of siphoning off cash abroad and indulging in trade-based money laundering. Summary of investigation. From the foregoing investigation, it appears that AMPL, APRL and EIF, various related entities of Adani Group, Shri Vinod Shantilal Adani, Shri Jatin Shah and Shri Mureshwar Vasant Rabde of EIF and others have conspired between themselves to execute the planned conspiracy of siphoning of foreign exchange abroad to and for the benefit of their related entity, APML and APRL, appear to have indulged in trade-based money laundering by trade mispricing for routing invoice through an intermediary invoicing agent EIF in the UAE, a front company of the Adani Group run and controlled by one of the Adani brothers and assisted by ex-employees of the Adani Group. EIF in UAE appears to have been created as a front for siphoning of money under the guise of outward remittance for overvalued imports. By indulging in invoice inflation, the modus operandi can be diagrammatically described as under. Source: Director of Revenue Intelligence Report. Please like the video, subscribe to the channel, share as much as possible, give your comments, and thanks for watching.